Good afternoon, everyone, and welcome to the November edition of our Third Thursday webinar program. Today, Mike Grotty, a partner at Caselaw, will be presenting us with his legislative and case law update, looking back at the laws and cases that shaped 2022. We're also pleased to announce the final Third Thursday webinar of the year, with next month's public official training seminar being held on December 15th. We'll be sending out the invitation with additional details soon, so keep an eye on your inboxes. Before we get started, I'd like to remind you that as a PIRMA member, you can call the PIRMA Legal Access Hotline for up to 120 minutes of free legal advice. These consultations can be on a vast array of topics, including employment issues, zoning and land use matters, law enforcement, liability issues, contract review, governmental immunities, and much more. PIRMA.org will have information, or you can reach out to the hotline directly at 855-607-4762. As always, we welcome your feedback on any of the programs PIRMA offers or programs you would like to see, so please complete the survey we send out following the webinar and provide your valuable feedback. Thank you for attending today's session. We hope to see you in the future. With that, I'll now turn it over to Mike.
Great, thanks, Andy. Let me just get us going here. So yeah, my name is attorney Mike Grotty, and I'm with Siena Law, and I want to give you an update on some of the legislation and some of the case law that's come down in 2022 for us to watch and pay attention to as we get through our normal lives as township and boroughs and municipalities generally. To give a bit of background on myself, I've been with the firm for 18 plus years doing municipal law, and I do it essentially wearing two hats. The first hat I wear is representing townships and boroughs and authorities and zoning hearing boards directly as the day-to-day solicitor. So I'm there at the meetings when we're getting yelled at and when we're getting praised. Just kidding, we never get praised. The other hat I wear is assigned defense counsel through PIRMA, obviously representing townships and boroughs and authorities and zoning hearing boards across the state when we get sued. And of course, we get sued for everything, including ranging from trip and falls to Section 1983 civil rights lawsuits to right to know act appeals. So it's a broad range of stuff that we have to handle. If you have any questions as we go through the presentation, feel free to put them in the Q&A or in the chat session. Andy will try to interrupt me if I miss it, but we'll try to get those questions answered as we go. So kind of to break down what we're going to talk about this afternoon, it's going to be first legislation of note that was approved in 2022. And I'll first speak to the legislative process generally and how that works, because that'll give a framework for what happens next. And then I'll talk about legislation that's going to be on the horizon for the next legislative session in 2023. And then lastly, I'll go through some case law that's come down in 2022. And when I go through all these, my intent is not to give a law school dissertation on it, especially when we get to the cases. Some of the very technical legal holdings aren't as important as the bigger picture trend of what kind of suits are coming down and how the courts are ruling on them. So first, to get us all back to our first grade conjunction junction, how does legislation work? Pennsylvania models the U.S. House and U.S. Senate legislative process, or I guess to be more technically specific, since we came first, the federal model mirrors what we do here in Pennsylvania. That is, we have a bicameral legislative body. So we have the House and we have the Pennsylvania House, Pennsylvania Senate. The legislation that's proposed is put on a 2-year legislative track. So every 2 years, and we're currently in the 2021 through 2022 legislative session, at the end of December 2022, everything that's been proposed and set out there by the different Pennsylvania senators or representatives will all die on the table. It's all dead. And we start from zero in 2023 for what is the 2023 through 2024 legislative session. What typically happens is, there are thousands and thousands of bills that are actually proposed and put out there And the vast majority of those are repeats of what have been in prior sessions. And they either go to committee or they get proposed and then they kind of just sit there forever, likely having been proposed at the special request of a legislator, knowing that it's not really going to get any traction. But for those bills that do have movement, they are generally processed and pushed to the different committees, different House committees and Senate committees. They make referrals and recommendations. Sometimes there are even different arms of the Pennsylvania, like the Government Affairs Office or the executive branch, that give reports and recommendations on the legislation that's out there. Once it gets through committee, it gets before either the full House or the full Senate for a vote in one of their legislative days. And I think they're done or nearly done with any planned legislative days for our current year. So anything that hasn't been passed by those bodies at this point, unless there's a special session, is going to be dead. But once those are voted on, they then get reconciled, or they kind of bring the Senate version and the House Senate together and kind of mishmash them together into one bill that's then approved by each. And then it goes to the governor. And the governor has three things that he can do with the bill that's pending. He can sign it into law, and then it becomes law whenever it says it's going to be effective. He can veto it, or he can even line item veto it and just cut out certain portions of it. And if he does that, of course, that can be overridden by further votes of the House and the Senate. Or he can approve it by doing nothing. So if he lets it sit for a certain number of days, it eventually becomes law just by him not doing anything. So with that in mind, it's fortunately for all of us, I think, it's been a relatively quiet 2022 on both the federal front and the state front for new legislation that's come out. On the federal front, the U.S. Treasury Department issued its final guidelines back in January of 2022 on how we as municipalities can use that ARP money, the American Rescue Plan money. And if everyone remembers, there were all these pretty narrowly crafted categories of things that we could use the money for. And there was about 250 pages of a first draft of the rule that the Treasury Department put out. And in the end, the Treasury Department put out still as long of a set of guidelines in its final rule. But the one main carve out they allowed was one of the uses we could use the money for is to make up for lost revenue to the municipality. And they essentially gave us a kind of blanket standardized check that if you're receiving less than, I think it's $1 million or $10 million in ARP money, you can use that toward any general governmental purpose under the guise that it is assumed that that's the amount of money that you lost through revenue because of the pandemic. So that's great because it opens up quite a ways the ability for us to use the money for any of our general township or borough needs that are out there. We don't have the handcuffs or blinders on as much as we did when they first came out. Next, there was the State and Local Government Cybersecurity Act of 2021. Even though it says it's of 2021, it was actually not enacted until 2022. That allows us additional resources through Department of Homeland Security and through the Pennsylvania Air National Guard Defensive Cyber Operations and the PA Air National Guard Cyberspace Operations to respond to cybersecurity threats. So they will each be an additional resource at our hands and fingertips to the extent that you as a township or borough or even authority have a cybersecurity issue. And if we remember from, I think it was just about 1.5 years or 2 years ago, there was an authority in Florida, a water authority in Florida that did have a cybersecurity event, and they were hacked, where the hackers tried to change the mixing protocols for the chemicals that went into the water, have it treated. And that would have obviously been very bad if that actually went into effect. That was caught by their cybersecurity protocols and corrected before anything was affected. But it's still just a warning to all of us to think, none of us are too small to have a cybersecurity event, and to be careful and mindful of that, of course, noting that we now have these additional resources out there to respond to them. For state legislation, again, fortunately, it's been a relatively quiet year in legislation. The state budget was enacted roughly on time, and it was a surplus budget. So there was there's not expected to be many cuts to money that would otherwise flow down to us at the municipal level. There may be, I think I did hear, because of inflation, that there may be some adjustments, less expected money through liquid fuels next year. But that of course remains to be seen. Those are just estimates right now based on the taxes that come in. In terms of the state legislation that was enacted, a couple of the ones that are notable. The first one is Act 97 of 2021. This one, I don't want to say snuck through, but it went into effect around July of 2021, and it changes how we can hold financial security for big developments. So to step back a half step, when a developer comes in to develop a big property and they've got 250 new homes that they're building with new roads and everything else, stormwater management, they of course have to put up financial security. As part of that, the municipality's planning code allows us to have them put up an additional 10% as a bit of a buffer. So to give an example, if there is a $1 million worth of roads and stormwater management improvements and other public improvements the developer needs to do as part of its development, we can make them put up $1.1 million. And then as they do the work, that money is reduced based on the amount of work that's left over. Well, the way that a lot of municipalities were handling that in the past was, as the work was done, as that $1 million worth of work was done, you're obviously reducing that $1 million, but a lot of municipalities were keeping the 10% at the original amount until the very end of the project. So if you have $1 million, you have $100,000, that's 10%, and that retainage amount, you keep that $100,000 as $100,000 until the project is fully complete. And the logic behind that is to make sure we have enough buffer that as prices go up and things change on the ground, if the developer doesn't do certain work, we still have money to collect against it. But along came Act 97, which harmed our ability to do that. Instead, what Act 97 requires is that as we reduce that $1 million, the baseline financial security, we have to reduce the retainage by a similar amount. So if someone does $600,000 worth of the $1 million in the public improvements in the financial security, that $1 million, the baseline is reduced to $400,000. That's how it's always been. But in addition to that, the retainage would also be reduced to $40,000. So now we're only holding $440,000 in financial security instead of $500,000. We have seen some developers jump on this already and come in with requests that their financial security be reduced, even without doing any more work, because of the past work they've done and the amount of retainage that's left over. The problem for this, of course, is it tightens the belt on us in terms of how much money we have in financial security to to serve that purpose, to be security. So it requires that our engineers be a little bit more diligent when they are looking at financial security releases, that they not only look at what's being released, we also look at what's left over. And even though they might have done $100,000 worth of work, if the cost of doing the stuff that's left over has gone up, that might be a cause to not release the full amount of that money in the financial security to keep your financial security balance where it should be, which is, at the level. The other thing it does, it puts more pressure on us as townships and boroughs to make sure to do that annual or biannual check on how adequate our financial security for the different developments is. And if it's not, require the developer then to post additional financial security to do a catch up. Next, House Bill 979 passed both the Senate and the House of Representatives. And what it did was it actually put back into effect a regulation that was approved, God, I want to say about 8 years ago, that would have preempted our ability and prohibited our ability as townships and boroughs to regulate local firearms in any way. Okay, so that's kind of always been out there anyway under the Second Amendment, but it would also allow that anyone who wanted to challenge our ordinances for potentially regulating local firearms in any way could do it, including guns rights groups like the NRA, and they would get attorney's fees if they won. So that creates a bigger incentive for those organizations to then file suit against us. When this legislation came out about 8 or 10 years ago, it was actually challenged on procedural grounds. The legislation was because the legislature added too much stuff into that bill. It's called the single source rule. And so that was invalidated. Well, they took another crack at it, and it actually passed the House, passed the Senate to again put that type of provision in place. But fortunately, it was vetoed by the governor. Next, some more mundane ones. The Act 45 of 2022, the Interstate EMS Compact. This act joins Pennsylvania with 22 other states to require certain mandatory baseline testing, standardized testing and training for EMTs and paramedics. And my understanding of this is, while it does set standards, which a lot of folks don't like additional regulation, additional standards, it makes it more standardized across all these states, so that if you have an EMT or paramedic that's coming from elsewhere and they've met those standards there, then hopefully they can be then applied when they're joining our more local departments. Next, Act 57 of 2022. This is another piece of legislation that a lot of us probably won't have any direct interaction with or even apply it in any way, but we're still required to do something. So this act amends the local tax collection law so that if there are new property owners who are just getting a piece of property for the first time and they don't pay the tax bill on time and they get the penalty assessed, they can request forgiveness of those tax penalties if their tax bill wasn't received by them. And there's a few other restrictions and hoops they have to jump through. And the logic behind this was, apparently there are a lot of folks who, when they buy their new house or new property, the tax collectors had been sending the tax notices to the prior owner, and the new owners don't get it until after the penalty period has already kicked in. So this essentially gives them that waiver that within a year of them purchasing the property, they can get relief from those penalties if certain conditions are met. The thing that I put in bold here, and all of us should walk away with, is under the act, each municipality is required to enact a resolution to implement these provisions for a tax collector. And PSATS has a model one that I know they've sent around before, but I can certainly, if anyone touches base afterwards, certainly send it out to you. But it essentially mirrors what the state act requires. But for whatever reason, the act requires us to pass a resolution at the local level to, again, mirror what the state legislation says. Next, for anyone who is been tasked with or looking into ways to make housing more affordable in your area, we do have another tool that's been given to us by Act 58. It allows essentially tax credits to be given by us at the local, as a local taxing authority, to provide incentives for improvement to deteriorated areas for the creation of and improvement of affordable housing units. And the one nice thing about this bill, or now this act, is that it gives a specific definition of what affordable housing is, because that's been lacking in a lot of other regulations and a lot of other efforts to try to define and pinpoint that issue. And so it gives you a kind of a more concrete standard against which to measure what is affordable housing, so that you can put both this in place. And if you have other zoning where you're going to try to incentivize affordable housing through other zoning measures, it gives you at least a definition you can steal from to use in the zoning world. Next, the big one, if you remember a couple of years ago, the fireworks law went into effect to allow anyone to buy consumer grade fireworks and shoot them off. And we were preempted at the local level from any regulation, any use of them. That's now been pulled back with the modification to the fireworks law under Act 74. And instead we have new measures we can take, and there's new regulations in place for fireworks and fireworks sales. So for fireworks sales, they can't use display fireworks. Those are the big ones within 300 feet of a sales location. Okay, that's not a big deal. It provides a municipal permitting process for these display fireworks, and that's not transferable. It's only for the person that comes through and applies for the permit. And in doing that, the legislation gives us the ability to impose, quote, reasonable rules and regulations, whatever those might be. The fire chief is also given the authority to determine if certain fireworks are being used in a hazardous manner to a person or property. And for people who are selling them, it imposes insurance requirements of at least $1 million. For consumer grade fireworks, these are the fireworks that some of our neighbors are shooting off, often late at night. Some additional regulations come into play, as well as our ability as a municipality to impose our own regulations. So the regulations that are in the bill and the act are, of course, you can't direct it at a person, vehicle, or building. Okay, that makes sense. You can't do it while intoxicated. Easy. You can't do it within 150 feet of a building or animal housing facility or livestock area. But you can use it for the protection of agriculture. Apparently, fireworks are used by farmers in some instances as a bird deterrent. But the 150 feet is certainly a critical one for a lot of us to start to apply as we start to regulate these. This act gives us as municipalities the ability to regulate them and establish our own rules that are not in conflict with the legislation. So we can impose our own standards. We can prohibit them altogether outside of 10 a.m. to 10 p.m. except certain holidays. There are a list of holidays that are in the act where the anyone can shoot off fireworks, even if it's beyond those 10 to 10 time periods. And of course, there's a 12% sales tax that's now going to be applied to it. More recently, kind of toward the tail end of the fall here, 2 more pieces of legislation came out. The first one being Act 130 of 2022. And this is highly automated vehicle deployment. It allows for the testing of driverless vehicles in Pennsylvania and having them on our roads. This is one more step to more commercial use of driverless vehicles in the state. And obviously, that's being carefully monitored. And I'm not sure how the machines work, but I'm sure it'll be an issue coming down the pike at some point in each of our townships and boroughs in the next 5 years at a minimum. Next, junior firefighters. In an effort to give one more, tool to fire companies to get more volunteers. They've put the legislation through so that they can have junior firefighters to help serve and volunteer for the fire companies with the permission of their parents and the fire chief, and it doesn't violate any child labor laws, which apparently was a concern before. Legislation on the horizon. These are a couple categories of legislation that have been proposed in the past 2 years, and for some of these even more, and will likely be coming back up in the 2023-2024 session. So it's stuff we're going to continue to keep our eye on, and I'm sure you would as well. First one is local police use of radar. I've heard of this one for over 10 years, this being an issue where, of course, the state police can use radar guns, but our local police departments can't. There have been a variety of different proposals over the past several years and past several legislative sessions to allow local police to use radar in certain circumstances, but those have all died on the table. And some of those have been that you can't use it as a money generator. You can't use it, can't use it as part of a quota, and you're limited in terms of how many tickets you issue. There's been everything all over the board, but all of those have eventually died on the table and not gotten anywhere, leaving us for speed enforcement with the painting the lines or using other measures other electronic speed devices to measure people's speed. The local police use of radar is probably going to be one that's going to crop up again in the next session. Next, probably the one that's got the most fire behind it for movement is going to be this next category, the modifications to the Tort Claims Act. So if we all remember, the Tort Claims Act gives us immunity from lawsuit for certain negligence or tort claims. And we can only be sued in certain categories of torts that are out there. Anything else we can't be sued for under tort, at least. The other big thing the Tort Claims Act did, though, is it limited, even if we got sued under those for like a slip and fall or a vehicle accident, our liability is capped at $500,000. And that's been capped at that amount since it was first enacted in the early 1980s, 1984. The $500,000 limit was set back then, and it hasn't changed since. There have been a number of legal challenges to it, both back in the 80s, but several more recently in the past few years to try to challenge the validity of that cap. And at each turn, the Pennsylvania Supreme Court has upheld it. However, in the latest rounds of challenges to it, when it upheld it, the court clearly held its nose and noted that this is a legislative issue that the legislature should take care of, and that if it doesn't, it's going to step in at some point and take care of it for it. There was a Pennsylvania, I think it was the House Government Affairs Committee report that was issued over the summer, and some hearings were held on the Tort Claims Act and how it should be, how and if it should be modified. And it came to the conclusion that the vast majority of claims for torts against municipalities fall way, way under the cap. But there are certain serious incidents, like where people lose a leg or lose a limb or lose their life, called catastrophic injuries, where the cap has been hit and that have kind of worked an unfairness into the system. So the proposal by that committee was that the main portion of the limit stay at 500,000, and if there's going to be a change, only limit that to catastrophic injury claims. And even then, it's still limited to, I think it was $1 million or $2 million for those, with an annual CPI adjustment, so that they need not revisit it back in legislation again. That still hasn't made its way into a bill yet, or not at least one that's gotten any traction, and won't be passed in 2022. But I'm sure that it'll be something that's going to come up again in 2023. Next, notices for approval of collective bargaining agreements. This one had been in the mix for at least the past 2 legislative sessions. Different efforts to require that CBAs for police departments, that we have to go through additional hoops before we pass them. Frankly, in my opinion, the legislation that has been proposed was an effort to try to submarine CBAs and make it very politically difficult to even pass them, which would work a bigger issue with us and our police departments and our other union workers in the townships and boroughs. Those haven't gotten anywhere in the past, those legislation, but I'm sure that they're going to come up again. Next, the Prevailing Wage Act. This one, these changes have been talked about since 2000, the early 2000s, the issues with Prevailing Wage Act. Essentially, the Prevailing Wage Act adds at least a 33% bump to the cost of any project that we do as a township or borough. And that's because we have to pay these higher wages, or have our contractors certified that they're paying these higher wages at rates that the state sets. And there have been all sorts of proposals out there, either to increase the threshold limit for the prevailing wage when it would kick in, because I think it's 25,000, to eliminate it altogether, to expand it, to make it so that it's every project is prevailing wage. So it's been all over the board. I'm sure those are all going to come up again, because we're going to have a split between the political party that's in the House and the Senate and the political party that's in the governorship. I don't expect that those will get much traction even in the next 2 years. And lastly, there's been kind of a baby step push over the past couple of years for the legalization of recreational use of marijuana. Of course, we all saw a few years ago when the medical use of marijuana legislation came out, which preempted us on the local level from regulating any of those facilities differently than we regulate any pharmacy or any other industrial use for the growing operations. And I expect that if recreational use of marijuana was legalized, it'll probably continue that trend where we are preempted or prohibited from specifically zoning or limiting the zoning for those types of uses if it comes down. One of the reasons why I put this on the list was Fetterman, who's now a senator-elect. Remember, if we remember from a year and a half or 2 years ago, he did engage in a listening tour statewide where recreational use of marijuana was the main thing on the books. Next, jumping to case law of note. Of course, as we saw the other day, Donald Trump has announced that he's going to run again. And with it is going to, I'm sure, come a lot of the political sign, election sign, and flags issues that many of us encountered over the past few years. And that's been political signs with profanity on them. And those come in the form of, these signs that stay up not just for the specific election cycle, but ones that people put up year round as political message signs, not just campaign signs. So the warning here comes from Roselle Park, New Jersey. It's not a Pennsylvania case. It was instead a federal claim, but it mirrors a lot of the things we've been seeing. If you look in the bottom there, that's an actual photo of the signs that Mrs. Dick put up. She put up a variety of anti-Joe Biden signs. The neighbors were in an uproar, mainly because of the use of profanity in them, including the F word and some other things. I've seen those elsewhere, of course. The mayor and the other officials made very public statements to call on her to remove the signs, citing the obscenity language in the ordinance. And the ordinance had pretty standard obscenity language that you can't put up signs where the messages are obscene, profane, or whatever else. Those are often unconstitutional, by the way. And there was code enforcement fine threatened against Mrs. Dick by the code enforcement officer. And then the ACLU and Mrs. Dick both filed suit. And the appellate court in New Jersey found in her favor, finding that the the regulation that was on the books for that municipality was unconstitutional because the language itself violated the limits in the language itself violated her First Amendment right of free speech. In my experience, having dealt with this a number of times, when we get circumstances where people are complaining, it's almost always the same narrative. There's a sign that says F somebody, some political character, and it's always like put up right outside of a school bus stop where kids are waiting for the school bus and neighbors are in an uproar. The way that it seems to have been a little bit effective in dealing with these is to make the friendly approach. That person has put the sign up and to explain to them, not as a threatening, you're going to be in violation of X, Y, and Z take, but instead, hey, here's the situation. We've got these kids, they're waiting for the school bus stop here. Can you change your sign? We don't care. Just get rid of the profanity in the sign. We're not requiring you to do it, but if you could do it, that'd be great. 9 times out of 10, that works. Most people are reasonable and they either change the sign to something else or they get rid of it. That's not going to stop that 1 out of 10 people from still thumbing their nose and saying, you know what, I don't care. This is my right, et cetera, et cetera. Next, a big one. I see Mark is on the line. A big one in the world of PRDs, or planned residential developments. Here, there was a planned residential development for 95 dwelling units on 65 acres. 83 of those units were only accessible from a single road or bridge that would be placed on the property, and those units would otherwise be surrounded by water. The township denied the plans because of the public interest objections, among other reasons, in the PRD language, the PRD ordinance. And the trial court, when it got it, it reversed our denial of the plans for that reason. But fortunately, once it got up to the Commonwealth Court reversed that reversal, upholding the board's initial decision that it was a valid safety consideration for the township to bring up that there would only be one means of access to all those units on the property, and it was then a valid reason to deny that particular plan. There's a petition for allowance of appeal that is pending by the applicant to the Supreme Court on the issue, so that remains to be seen whether the Supreme Court will take it up. Next, in the in-rate petition of Jackson Township to sell a piece of property, Jackson Township had a 250 lot development come through. I think it was about 250. And a couple of the lots were designated as open space, and they were donated to the township. And they were donated under the Donated and Dedicated Property Act, which is how we take and accept public open spaces for a lot of purposes. Over time, the township started planning and thinking about what they wanted to use that lot for. And they even put it to their open space board. And it came to the conclusion that it was not practical in any way to develop it as a public park. It had a lot of slopes. It was very wooded. It had, I think, a creek going through it. It cost a lot of money to do anything on that site. So the township petitioned the court to sell that piece of property and not have it be used for a public open space, public park. And there were neighbors who, of course, objected to that. And both the trial court and the Commonwealth Court disagreed with the township, holding that no, that even though it cost a lot of money, and even though your environmental commission and your park and rec board held that they couldn't use it for any reason, the property could continue to serve as some sort of pocket park or open space. And because you accepted it under that Donated and Dedicated Property Act, you township can't get rid of it and change its purpose. So that's just a warning for us when we get a piece of property, particularly as part of development. If it's coming to us as the township, we're going to have strings that are on us in terms of what we can use the property for. And if we want to use it for anything else, and there's objections to it, it can be tough to overcome those objections to use it for that other purpose. Next, Croft v. Donegal Township. Here, a township supervisor brought a First Amendment retaliation claim against her other board members after she was a vocal critic of most of the board's policies. So obviously this was a split board. You have one supervisor who was apparently criticizing everything the other two did. And then she claimed for a variety of reasons that she was being retaliated against on the basis of her being vocal as a supervisor to the different policies of the township. And fortunately, the federal court threw it out on a motion to dismiss, holding that the other officials are entitled to qualified immunity. Obviously, from our perspective as municipalities, if any one supervisor can start suing the others because they disagree, we're all going to be in a lot of hot water. Separately, there was an auditor surcharge against Croft and one of the other supervisors, and that was withdrawn by the auditors, I think at kind of the last minute. And then there's a whole separate legal fight for Croft to try to recover her attorney's fees in trying to fight back against the auditor surcharge. Next, this one is one that we had on our list last year, and it'll likely fall on our list next year. So in 2021, the Pennsylvania Commonwealth Court held that the Stroud Township ordinances were unconstitutional in how they regulated the discharge of firearms. What it found was that because that township prohibited firearm discharges except for police, hunting, or approved indoor and outdoor shooting ranges, and it only allowed shooting ranges in a very narrow subset of zoning districts, that the ordinance was unconstitutional as violating the Second Amendment. That's now been appealed to the Pennsylvania Supreme Court, which this summer accepted the case for review on that issue. That is, whether the township can impose regulations on shooting ranges, I'm sure a lot of us do, to try to limit how their impact on the neighboring properties and make sure that there's appropriate backstops and everything else in between. So the Supreme Court has now taken that up. It's being briefed. I think the briefs are just now trickling in, and there will likely be argument in front of the Supreme Court early next year, and hopefully a decision by mid-year of 2023. So it's another one to keep an eye on, especially if you have shooting range provisions in your zoning ordinance. Next, of course, cell towers are still making headlines, and these are not the 5G ones. This is more of a traditional one. Vertical Bridge sued Doylestown Township. It had come in for a traditional cell tower, and I think it was like 185 feet in height in the middle of a commercial area, but was a commercial area that's surrounded by residential areas. And Vertical Bridge came in with, as they usually do, these RF engineer, radio frequency engineers, and they had their fancy maps which show the different colors. And according to their maps, there was a gap in coverage for a certain area of town. And because of that was one of the conditions of the zoning ordinance that be addressed and fulfilled is one of the elements that someone has to prove when they get the zoning relief for it. They held like, look, we got RF engineers, and they show that we have a gap here, and we're going to fill it with this tower. And what the collection of neighbors had done was they actually went out and did a pretty systematic testing of their own cell phone coverage in all of those areas, and showed that there was no gap in coverage, that they all had coverage in all those areas. There were two limited areas that they didn't have coverage in, and those areas wouldn't have been given the coverage even with the RF maps that Vertical Bridge had filed. Vertical Bridge then did two things, because these cell tower cases take two separate routes. They do the traditional land use appeal route, which they did. And then secondly, They filed a Federal Telecommunications Act lawsuit against the township, claiming that we violated their rights. And the federal court matter went first, and it agreed with our position. It held that no, even though they might not be experts, the on the ground evidence by those neighbors that there was in fact coverage in those areas did negate that there was a significant gap in coverage, and therefore they didn't meet the ordinance criteria, and it was acceptable for the township to deny them. There were also a number of setbacks that the zoning ordinance imposed against the facilities themselves. So it's important to check your own ordinance to make sure if and how you regulate cell towers, are there setbacks for it? Because this one failed to comply with those setbacks. Next, North Coventry Township versus Tripodi. This is one in our neck of the woods. There was a 14-year plus enforcement action that was brought against the Tripodis for the dilapidated condition of their property. They had I think it was a townhouse or apartment complex unit, and it was in serious neglect. They had all kinds of electrical, property maintenance, and other issues. The local judge actually held them in contempt. The landowner was held in contempt by the trial court for failing to keep the property up after all these efforts to try to force them into compliance, including fines. And ultimately, the court held that the property was going to be placed with a special master, and the special master was going to be directed to have the property sold. The Tripodis fought that, and the Commonwealth Court affirmed the lower court, holding that it had the authority to do that, given the long history of non-compliance and the condition of the properties. Next, Horizon House versus East Norton Township. This one, a suit that was brought under the Fair Housing Act, where the Horizon House was going to propose a group home for folks with mental disabilities, and the township refused to issue the certificate of occupancy because the zoning ordinance itself required special exception relief for group homes for those individuals with disabilities. Despite that and a lot of other zoning ordinances have that language in it, there is federal case law to hold that is violating the Fair Housing Act, and therefore violating their rights to treat them any different than you treat a normal single-family dwelling unit, just because they have disability, even if they're in the group home setting. So the court held that the zoning ordinance was facially discriminatory in requiring the special exception approval, and then awarded attorney's fees. Fortunately for the township here, there were a whole host of other damages in terms of lost profits, lost revenue, and other carrying costs for the plaintiff that they claimed at the last minute against the township. Fortunately, the court kicked those out, mainly though because the plaintiff's attorney failed to give that information over until like the day of or the day before the trial in the matter. But for our purposes, it is important to note that if we get a Fair Housing Act complaint and we're in the wrong, they are entitled to attorney's fees, and they are entitled, if they provide us the information, to get the monetary compensation for their permits having been denied in any way. Next, just two more to note. First is PCIP Crumsville Road versus Greenwich Township. Here, this for any of us that have parcels in our township or borough along the turnpike is important, but the township rejected preliminary land development plans for the developer because the certain land had, before the land development application come in, had been conveyed over to PennDOT without any subdivision approval. And so the township took the position that that was inappropriate to do it. The Commonwealth Court, though, held otherwise, finding that PennDOT exercised its right of eminent domain to take that area to get the road, and that overrode the local subdivision regulations, and is kind of just another indication that the courts are taking a more hard look at our reasons for denying plans, the Commonwealth Court also held that that township acted in bad faith in its review of the plans because of the Commonwealth Court's belief that the reasons for denying were trifling, over technical, or unrelated to zoning. And that's stuff we're seeing more and more in the appellate court decisions, that they're taking pot shots at the reasons for denials of plans. And it does show that kind of shift in the sentiment of the court over the past decade or so to be much more landowner friendly and developer friendly, particularly when they're coming in for land use permits and approvals before us as a township or borough. And two more cases, and I note these not necessarily for the legal principles that are brought out in them, but just for the trend that we're starting to see, both in Mushroom Hill LLC and the In re Jandal case. Both of them deal with large, I'll call mega warehouses that are over 100,000 square feet. I think Jandal had 4 separate 100,000 square foot warehouses being proposed, and I'm not sure how big the Mushroom Hill one was, but the import of this one is just that more and more of these large warehouse projects are coming through. So if you're of a mind that you want to limit them to certain areas and make sure that the road network around them is going to be sufficient to handle them, jump ahead of that and get into your zoning now to start looking at that issue instead of waiting till one of them comes in, because these are coming in at a lot of places that none of us would have otherwise expected these big, huge warehouse projects and operations to plop down. And with that, I think if at the end of my notable cases, of course, there were more, but if anyone has any questions, feel free to ask them now, or you can shoot me an email afterward. But otherwise, thanks very much for your time.